Today, I am discussing all about the rules of sub res judice, sections 10 of the CPC. It simply means that the trial of the subsequent suit is precluded if there is a previous instituted suit based on the same cause of action or the same relief. This provision has universal application and has been adopted in the legal system of almost all the civilized country. No person shall be vexed twice for the same offense or for the same cause of action. The approach of these rules is identical with also the different law. As for instance, Article 20, Rule 2 of the Constitution says that no person shall be prosecuted or convicted twice for the same offense. Similar approach is also there under sections 300, rule subsection 1 of the CRPC, which lays down when a person once has been tried by the court of competent jurisdiction and acquitted or convicted, shall not be tried once again for the same offense while such conviction or acquittal remains in force. Therefore, the approach of these rules is also identical in different law also. Now, what is the object? The object of this section is to prevent, to preclude the trial of the subsequent suit if there is a previous instituted suit on the same cause of action, and at the same time prevent the multiplicity of the suit and to abuse the process of the court. Sections 10 of the CPC says that no court shall proceed with the trial of the suit in which matter in issue is directly and substantially in issue in the previous instituted suit between the same party or between the party under whom they or any of them claim litigating under the same title, where such subsequent suit is pending before the same court or before the court within the limit of India having competency to try it, or beyond the limit of India but established and constituted by the central government or before the Supreme Court. An explanation is also there which made it clear further that the pendency of a suit in a foreign court does not precludes a court in India the subsequent suit even if it is founded on the same cause of action. Therefore, the aim and the object of the rule contained under sections 10 of the CPC is that it precludes the two parallel courts, that the two courts having concurrent jurisdictions to entertaining and adjudicating the two parallel court if it is founded on the same matter, if it is founded on the same cause of action and for the same relief. And it also prevent the multiplicity of the suit and the conflictions of the decision. And further, it also prevent the abuse of the process of the court for the end of justice. It may be noted here that it is only the trial of the subsequent suit is precluded, but not the institution of the suit, and the court is entitled to pass an interim order such as the order for interim injunction or the order for the receiver in a suit. Thus it is found that it is only the trial of the subsequent suit is being precluded if there is a previously instituted suit found on the same cause of action. In order to preclude the trial of the subsequent suit, certain conditions are necessary to be followed. First condition is that there must be two suits. One is a subsequent instituted suit and another is a previously instituted suit. Then in that situation, the subsequent instituted suit is precluded on the basis of previous instituted suit if it is founded on the same cause of action. The another conditions is that the matter in the subsequent suit must be the matter directly and substantially in issue. Let us consider with an illustration. Suppose A file a suit against B for rent. B contended that no rent is due. Here, the recovery of rent is a matter which is directly in issue, which is directly and substantially in issue. Let us consider with another illustration. Suppose A file a suit for the recovery of possession against B on the basis of a sale deed. And another suit is also filed for another land but on the basis of same sale deed. Then here in two suits, the genuineness of the sale deed is a matter which is directly and substantially in issue in between the two suits. Therefore, the matter in the subsequent suit must be directly and substantially in issue in the previous instituted suit. The third condition is that the party must be same. What is the meaning of a party? Persons who appears on record at the time of decision, he is supposed to be the party of the suit. An intervener in the suit is a party to the suit. But a person whose name is struck off and who is discharged from the suit or who died during the pendency of the suit, but his name erroneously continued in the suit, are not a party to the suit. Therefore, the persons whose name appears on record at the time of decision of the suit is a party to the suit, or a persons claiming under the party is also a party to the suit. As for instance, A file a suit against B and suit is dismissed, and further A file a suit as being heir of A, Therefore, A and a person who is heir of A, and if there is a two suits, one is filed on behalf of A and another is filed on behalf of heir of A, then in that situation the subsequent suit is precluded because the party also includes the previous. Therefore, the decision of the court is not only binding upon the parties only, but it also binds the previous. But there are certain persons who are not a claiming through the party, but he has some interest common to the interest of the party. Therefore, these persons are represented by the party of the suit, as for instance order 1 rule 8 of the CPC. If there is a representative suit and all the persons who has an interest common to the interest of the plaintiff is supposed to be the party of the suit. The another conditions is suit must be pending in the same court or in a court within the limit of India, having competency to try it, or in a court beyond the limit of India, but established or constituted by the central government or before the Supreme Court. But here it is material to state here that pendency of a suit in a foreign court does not precludes a court in India from trying the subsequent suit even if it is based on the same cause of action. Now, the another condition that the court in which the previous suit is instituted must be competent to try the subsequent suit. Therefore, the court in which the previous suit is instituted must be competent with respect to the territorial jurisdiction, with respect to the pecuniary jurisdiction, with respect to the subject matter, with respect to the jurisdiction over the subject matter of the suit. Therefore, the court in which the previous suit is instituted must be competent to try the subsequent suit. The another important conditions to be satisfied is that the party litigating under the same title. Same title. What is the meaning of same title? Same title means the same interest. If a person file a suit, suppose A file a suit for the recovery of possession on the basis of ownership under the domestic law, and further there is another suit filed on behalf of A against B on the basis of ownership under the personal law. Therefore, the subsequent suit is the trial of the subsequent suit is precluded here because in both the suit the capacity of the plaintiff is based on the ownership. Let us consider an illustration and another illustration. Suppose A filed a suit for the recovery of possession, and further A filed another suit for the recovery of possession as the mortgagor. There in these two suits, the capacity and the title of both of the plaintiff in both the suits are different. Therefore, in this illustration, the subsequent suit, the trial of the subsequent suit cannot be precluded. Let us consider another illustration. Suppose a file a suit for the recovery of possession of a mud property. And if there is a second suit filed on behalf of A for the recovery of possession as being the manager of the mud property. Therefore, in this situation, the titles is not the same. The title is being changed from one suit to the another suit. Therefore, in this illustration, the subsequent suit, the trial of the subsequent suit cannot be precluded. Therefore, the plaintiff must have filed a suit in the same capacity in both the suit. And now we have considered what is the test of the provision contained in Rule 10 of the CPC. If the previous instituted suit is likely to operate as a res judicata upon the subsequent suit, if it is so, then in that situation, the trial of the subsequent suit is precluded. I have already stated that the subsequent suit is precluded. But one thing is necessary to be stated here, that if the conditions laid down under Section 10 of the CPC is not strictly complied with, then even in that situation, the court is empowered under Section 151 of the CPC to stay the trial of the subsequent suit if it is necessary for the abuse of the process of the court and if it is for the end of justice. Further, the civil court is entitled to stay to consolidate the two suits if it is necessary for the end of justice. Under Section 151 of the CPC, as for instance, let us consider one illustration. If A file a suit for the declaration of title and for a permanent injunction against B, and B subsequently file a suit for the recovery of possession. Here, the matter in both the suit are not directly and substantially in issue. Here, the suits are different in nature. The conditions required under the Rule 10 is not strictly complied with. But even in that situation, the court, the previous court, is empowered to the court is empowered to consolidate the suit under Section 151 of the CPC. Another thing is also necessary to be stated here, that if the subsequent suit is succeeded and the decision is made in contravention with the provision of Section 10, even in that situation, the decision made by the court is not nullity and the decision should not be disregarded in the execution proceeding. I have already stated earlier that it is simply the trial of the subsequent suit is precluded and not the institution of the suit. Therefore, the court is empowered in which the subsequent suit is being pending to pass an interim order such as the interim injunction or the order for the receiver, order for the appointment of receiver, and the like order. Therefore, it is only the trial of the subsequent suit is precluded, and not the institution of the suit, and the court in which subsequent suit is pending is empowered to pass an interim order of injunction and receiver. I have already discussed. I have discussed here about the conditions and about the provisions contained in Rule 10 of the CPC, and I hope it would form a better idea about the concept of sections 10. Thank you.